exposed as how the Trump team feels right now. Von Hilliard, there is a ferocious legal battle taking place right now in court. Trump's lawyers are arguing that Stormy Daniels' testimony about the sex is so salacious that it taints the jurors' impression of Donald Trump, when the Bragg team is arguing pretty sharply that the account is what he sought to silence. Tell me how this argument is playing out right now.
Exactly. Number one, the jury has been dismissed for the day, so they're not watching and listening to this back and forth. But this was the re-upping of the motion for a mistrial here. And Judge Merchan is now hearing both sides make their case on this, because Todd Blanche is making the case that some of the more visually graphic details that were presented by Stormy Daniels during her line of questioning from the prosecution, including, for instance, the height differentiation to two and the feeling of the imbalance of power between her and Donald Trump and the spanking of Donald Trump on the butt with the magazine, that those were details that were prejudicial to Donald Trump, the defendant, in front of this jury, that they have nothing to do with the records case. The prosecution, however, is now arguing in front of Judge Merchan that they have everything to do with this case. Number one, they have to do with the credibility of Stormy Daniels, but also they are noting, then even offering, the prosecution is offering to put under seal a list of more graphic details that Stormy Daniels would have been able to provide in her testimony, but they chose not to extract or ask her about for the purpose of not tainting the defendant in the eyes of the jury. So essentially questioning, or telling the judge and telling the defense team for Donald Trump, all right, if you really wanted us to, have Stormy Daniels tell the whole story in even more graphic terms, she would have been able to do that. But we went just far enough in our line of questioning, with most questions being yes or no questions, just enough to make it clear that her story was credible and that she had veracity with the details of what played out that night of the one-night stand.
I mean, I think, Sue Craig, we do know a little bit about how difficult sex is in a court of law, right? Because only two people who really know about the intimate act are Stormy Daniels and Donald Trump. But again, taking Donald Trump's word for it, that the intimate act was something he feared the public knowing about so desperately that he went about this extraordinary act of setting up a shell company, because Pecker says, quote, I will not be a bank. So Stormy Daniels, who her own lawyer says there was a, quote, crescendo of interest in her story ahead of the election. Donald Trump believes these details are important enough and central enough to his ability to win the presidency that he goes through this extraordinary. There is not a shell company. There's not a reimbursement. This arrangement isn't set up to do anything else other than keep these acts away from the voters in 2016.
That's right. So now how crucial are they to the case? I think what we're seeing right now, is they're setting some tracks for an appeal. If I could just I think that they're going to say that this went too far, and they're trying to get it into the record now because this is going to go up on appeal if, in fact, he's found guilty. But they're arguing pretty fast and furious that a lot of these details just should not have come in, that it went too far. But these are the exact details that he was trying to shield the public from, the whole catch and kill scheme was based on, was to make sure the public didn't
know these things.
That's
right.
I mean,
and I have to ask you, and I hope you're not offended. I mean, would the spanking have made it into National Enquirer if that was part of the story?
The spanking most definitely would have, as it would have these details that they're going to potentially put under seal.
Would the condom have made it in the National Enquirer if the story?
It would have. I mean, every salacious detail would have been on the front cover of the National Enquirer as we headed into the election, off the back of the Access Hollywood tape. That was why this story had to be caught and killed. That is why this story had to be purchased off the market. That is why this story had to be silenced.
And that's why it was entered into evidence.
But is it
correct?
I'd like to hear Andrew on this, but my question is just because that is true, is it necessary that the jury needs to hear all of this? I don't know.
So the state has to prove its case beyond a reasonable doubt. The defense does not have to stipulate to anything. They can say, you have the burden, prove it beyond a reasonable doubt. They are entitled to show this salacious story. And in fact, the more salacious, the more motive there would be to suppress it.
And if you're saying that the condom, the spanking, all these details would have been in the National Enquirer, I mean, that's what Trump understood. That was his world.
It would have been on newsstands in every supermarket, in every airport, everywhere. just days before the election, and off the back of the Access Hollywood tape. That's why it was so damaging.
And Trump knows that's true.
Correct.
Trump knows that's true.